Hello and a very warm welcome to Thorough Newspaper Analysis for 7th of April, which is brought to you by LawSikho. Now let's proceed with the agenda for today. At the very outset, we're going to have a look at some of the important national and international news updates. This is going to be followed by two legal news updates. And at the very end, we have an editorial to discuss, the title of which is Open Justice. With this, let's start with the TNA for today. The first update is in the segment of personalities. So recently, Mukesh Ambani has been named the richest sports owner in the Forbes Billionaire 2023 list with a net worth of $83.4 billion. He has surpassed Steve Ballmer, the owner of LA Chippers, whose net worth is $80.7 billion. Now, next, we have an update from the segment of sports. So, Mahendra Singh Dhoni, the former captain of Indian cricket team, who led the team to victories in the T20 and ODI World Cups and the 2013 Champions Trophy, along with Yuvraj Singh, the player of the tournament in 2011 ODI World Cup, they have been named among the 5 Indians to be awarded the honorary life membership of the Malibon Cricket Club. Former India women's cricket team captain Mithila Raj and also pacer Jhulam Goswami, they have also been granted honorary membership by the club. The duo retired from international cricket last year after India's early exit in the 2022 ODI World Cup. Mithila Raj remains the top run scorer in women's ODIs with 7,805 runs spanning across 232 games. As far as this club is concerned, it has a long history of awarding honorary membership, life membership, to players who have made significant contributions in the field of sports and, of course, in the game of cricket. Moving on to the next update. Bandipur National Park, located in the southern Indian state of Karnataka, it has recently completed 50 years as a Project Tiger Reserve. The park, which spans an area of 874 square kilometers, it is home to a diverse range of flora and fauna, including tigers, elephants, and several species of birds and reptiles. This particular park was initially established as a wildlife sanctuary in 1973. However, a year later, that is in 1974, it was designated as Project Tiger Reserve. Since then, it has helped it has rather played a pivotal role in the conservation of tigers and other endangered species. Next is with respect to the geographical indication tags being given to 6 products from the state of Kerala along with others in other states of India. So according to data shared by the GI registry, Kerala has secured the highest number of geographical indication tags for products among all states in India in the financial year 23. Several products that have been given this tag in the state of Kerala, they've been listed out here on the screen for your kind consideration. In addition to this, or the 6 products that were selected from the state of Kerala, the GI registry selected Mithila Makhana, which is aquatic fox nut from the state of Bihar. Along with that, Alibag white onions from the state of Maharashtra, they were also selected for this recognition. Along with that, Tandoor red gram from Telangana, a local variety of pea from Ladakh, and handicrafts from the state of Assam, they were also selected. Moving on. So recently, this is an update with respect to the defense segment. The first lot of women will be commissioned in the Army's artillery regiments later this month when they pass out of the OTA, which is the Officers Training Academy, Chennai. This will be the first time that women will be trained to use rocket systems. Women officers already fly fighter planes in the Indian Air Force and they serve on ships in the Indian Navy. The center has approved the Indian Army's decision to induct women officers in the artillery regiments. Minister of State for Defense Ajay Bhatt informed Lok Sabha on 31st of March. This particular decision to induct the women, it was taken on March 20th. In the beginning of this year, in January, General Manoj Pandey, the Chief of Army Staff, he announced a proposal to induct women officers in the artillery regiment, and this was sent to the center. He had said that gender empowerment in army, it is an area of priority for the forces, and that women will be they would do really well in the artillery regiments. Moving on to the next update, which is again in the segment of sports for today. So, India, US, they are to begin major air combat exercise COPE India in West Bengal, enhancing military cooperation between the two nations. The Indian Air Force and the Air Force of the US, they are going to hold air exercise COPE India with Japan as an observer nation. This exercise will be conducted from 10th of April to 21st of April this year. As far as this the modalities of this particular exercise is concerned, it's a bilateral joint exercise between the Indian Air Force and the United States Air Force. COP India, it began in the year 2004 as a fighter training exercise. The exercise has evolved to incorporate subject matter expert exchanges, air mobility training, airdrop training, and large force exercises in addition to fighter training exercises. This exercise will further enhance operational capacities and capabilities between the two air forces. The last edition of this particular exercise was held in the year 2019. Now, with this, we've come to the international segment for today. So, see, India and Japan on Wednesday agreed to diversify their defense cooperation in the new and emerging domains like space and cybersecurity as part of an aim to consolidate the overall strategic engagement, the Minister of Defense said in a statement. The decision to further expand defense ties, it was taken as at the 7th edition of the India-Japan Defense Policy Dialogue, which was co-chaired by Defense Secretary Giridhar Armane and Japan's Vice Minister of Defense for International Affairs Oka Masami in Delhi. It said the Japan Vice Minister, he presented policy updates from their recently released National Security Strategy and National Defense Strategy. Moving on to the next update, this is an interesting update indeed. In recent years, there has been a shift in the global currency landscape, with China's yuan steadily gaining ground against the US dollar. This trend is now reflected in Russia, where the Chinese currency has now overtaken the dollar as the most traded currency. According to data which was recently released, the yuan accounted for 23.6% of Russia's foreign exchange turnover in the first quarter of this year, while the dollar share was 22.5%. This marks the first time the Chinese currency has surpassed the US dollar in Russia's market. And this rise of the Chinese currency in Russia, it is a part of the broader trend of increasing acceptance of the Chinese currency in international market and international trade and finance. China has been actively promoting the internationalization of its currency, encouraging its use in cross-border transactions and investing in infrastructure to support its use in the global market. Moving on to the next update. This is with respect to Ukrainian president being decorated with Poland's top award. The highest decoration of Poland, the Order of the White Eagle, it was presented to Ukraine's President Volodymyr Zelensky by the President of Poland, Andrzej Duda, during a meeting between the two leaders at the President Palace. The office of the President of Republic of Poland stated that Zelensky was awarded the Order of the White Eagle, the highest honor, as recognition for his contributions towards strengthening the relationship between Poland and Ukraine, promoting security and advocating for human rights. Moving on to the next update, or which is the first update in the legal update segment for today. So this is coming from the High Court of Himachal Pradesh. The High Court has held that if a couple has access to each other, then it is conclusive proof of legitimacy of the child, and hence the presumption under section 122 of the Indian Evidence Act, it gets attracted. Moving on to the next update in the segment of legal updates itself, which is coming from the Honorable Top Court. So, in a significant judgment, the Apex Court has held that the amendment brought to Section 153C of the Income Tax Act of 1961, it shall be held to be retrospectively applicable. The provisions allow Revenue Department to proceed against a party other than the person who is being searched. The name of this particular matter is Income Tax Officer versus Vikram, Sujitkumar, Bhatia, and 14 connected other cases. Now with this, we've come to the last segment of today, which is the editorial segment, the title of which is Open Justice. तो एसेंशियली अगर हम इस पूरे एडिटोरियल आर्टिकल का मुद्दा देखें कि वाई ऑफ दिस पर्टिकुलर आर्टिकल, तो एसेंशियली देखिए हुआ क्या था। एक मलयालम न्यूज़ चैनल था बाय द नेम ऑफ वन मीडिया। तो वन मीडिया जो न्यूज़ चैनल है उसने अप्लाई किया था मिनिस्ट्री ऑफ आईबी को टू रिन्यू इट्स लाइसेंस। अब जो आईबी मिनिस्ट्री है, विच इज़ योर इंफॉर्मेशन एंड ब्रॉडकास्टिंग मिनिस्ट्री, इट डिड नॉट रिन्यू द लाइसेंस ऑफ दिस पर्टिकुलर चैनल। एंड उन्होंने जो रीज़न दिया कि हम रिन्यू क्यों नहीं कर रहे हैं, वो ये है कि जो मिनिस्ट्री ऑफ होम अफेयर्स है उन्होंने इस पर्टिकुलर चैनल का जो सिक्योरिटी क्लियरेंस है वो नहीं क्लियर किया, इसको सिक्योरिटी क्लियरेंस नहीं दिया है। सो एज अ रिजल्ट वी आर विदहोल्डिंग द रिन्यूअल प्रोसेस ऑफ द लाइसेंस ऑफ दिस पर्टिकुलर channel. Eventually, then the matter reached the Kerala High Court, and then the matter has come up before, or it came before the Honorable Apex Court, and इसी के रिस्पेक्ट में सुप्रीम कोर्ट ने कुछ डिसीजन दिया है, वही हमारा आज का चर्चा का मुद्दा होगा। सो दिस इज एसेंशियली द क्रक्स और द वाई ऑफ दिस पर्टिकुलर टाइटल। अब हम देख लेते हैं एक बारी brief framework iska ki how are we going to go about discussing this particular article. So essentially we're going to have a look at the factual matrix of this particular case. We're going to understand as to how the case emanated and what did the High Court of Kerala say, and then what did the Honorable Apex Court held in its ruling of Wednesdays. Then we're going to have a look at why this particular ruling is significant. We're going to have an understanding of the entire seal cover procedure and what the Honorable Apex Court said with respect to that. And then we're going to have an understanding of what the top court said when it said that Supreme Court ने काफ़ी relevant observations इस particular matter और judgment में the court has given, जहाँ पे सुप्रीम कोर्ट ने ये कहा है कि अगर आप किसी अग्रीव्ड पार्टी को रेलेवेंट मटेरियल का एक्सेस ही नहीं दोगे, तो जो कॉन्स्टिट्यूशनल रेमेडीज है टू अप्रोच द कॉन्स्टिट्यूशनल कोर्ट्स, वो तो फिर दे आर गोइंग टू बी रेंडर रिडंडेंट. So इसके respect में there are certain observations, and then we're going to have a look at what the Supreme Court had to say with respect to the decision of the Kerala High Court, and then we're going to have a look at what the top court said about giving a blanket immunity to the government, saying that we cannot produce a certain sort of or piece of material before a party because it falls under the category of national security. तो क्या ये blanket जो एक blanket एक्सेस जो स्टेट यूजुअली ले लेता है, तो इज दिस वायबल, एंड अगर नहीं तो व्हाट इज द टेस्ट दैट वी फॉलो. तो इसके रिस्पेक्ट में टॉप कोर्ट ने ये कहा है कि द स्टेट हैज टू प्रूव दैट देयर आर कंसर्न्स ऑफ नेशनल सिक्योरिटी एंड देयरफॉर वी आर नॉट डिस्क्लोजिंग द मटेरियल. एंड देन द कोर्ट हैज टू सी कि क्या एक प्रूडेंट पर्सन भी इस चीज़ को मानेगा कि हाँ देयर इज ए कंसर्न ऑफ नेशनल सिक्योरिटी एंड देयरफॉर द मटेरियल कैन नॉट बी प्रोड्यूस इन इट्स यूजुअल मैनर. And then the court has devised in order to strike a balance between the competing needs of having the concern of national security addressed by non-disclosure of certain pieces of material, and also the individual's right or the principle of natural justice, whereby an individual has a right to have access to the charges that are against the individual, or here in this case the material that has been cited against the channel for the non-renewal of the license. So how do we balance these competing interests? So with respect to this, court ने दो suggestions दिए हैं. One is with respect to giving the gist of a certain sensitive portion of any information to the party concerned. तो हम पूरा information नहीं disclose करेंगे, हम उसका gist देंगे. And secondly, appointing an amicus. So we're going to have a look at all of these facets in detail. Now let's start with the facts of this particular case. So देखिए, significantly Supreme Court ने Wednesday को ये rule किया, and Supreme Court ने it ruled against the telecast ban that was imposed on imposed by the union government on this particular channel, which is a Malayalam news channel by the name of One Media. The court passed the judgment in an SLP which was filed by Madhyamam Broadcasting Limited, which is essentially the company जो इस channel को चलाती है. And the SLP, it assailed the decision of the High Court of Kerala, which uphold the decision of the Ministry of Information and Broadcasting to not renew the broadcasting license of the channel. And जो IB ministry है उसने क्यों नहीं renew किया था? Because there was the security clearance from the Ministry of Home Affairs, it has not come. So therefore, the particular matter went before the Kerala High Court, then eventually it came before the Honorable Apex Court. Now let's understand what the article highlights with respect to the decision. So it says that the Supreme Court's verdict in setting aside the denial of the broadcasting permission to the Malayalam channel One Media, it is one that protects the media against arbitrary action and it bars the use of undisclosed national security considerations as a pretext to shut down an outlet. The court has struck a blow for the media freedom by ruling that the government could not term critical coverage or airing of critical opinions as anti establishment and so initiate action. It said the use of a terminology represents an expectation. It represents an expectation that the press must support the establishment. The denial of security clearance to a media channel on the basis of views it was entitled to hold, it produces a chilling effect on free speech and particularly on free press or freedom of press. The bench also cited substantive grounds to allow Media One's petition. पहला तो कि security clearance cannot be denied based on its alleged anti-establishment stance or the very bold remark or claim that its shareholders they have a link with Jamaat-e-Islami. And secondly, the court has found faults with the approach of the Kerala High Court, which had accepted material in a sealed cover on why the Home Ministry denied security clearance to the channel. It expressed surprise that the High Court did not explain how it felt the denial of security clearance was justified, even after noting that the gravity of the issue was not discernible from the files. सो देखिए असेंशली क्या हुआ था कि गवर्नमेंट का जो स्टैंड है जिसे कि उन्होंने अपनी सिक्योरिटी कंसर्न्स को सॉर्ट ऑफ सब्सटैंशिएट किया वो ब्रॉडली इस बेसिस पे था कि जो स्टेक होल्डर्स है इस पर्टिकुलर कंपनी के एंड इस चैनल के उनके लिंक्स है कि कुछ आउटलेट्स हैं जो कि गवर्नमेंट की सिक्योरिटी कंसर्न को फर्दर फ्लैग करता है एंड वन ऑफ द जो आउटलेट जिससे उनके लिंक बताए गए थे दैट वाज जमात इस्लामी. तो गवर्नमेंट का ये कहना था कि जो इस चैनल के स्टेक होल्डर्स हैं उनका इस पर्टिकुलर आउटलेट के साथ लिंक है. देयरफॉर वी हैव concerns over the national security of our nation. So court का ये कहना है कि without giving concrete reasons आप एक बेसलेस बोल्ड सा क्लेम या असर्शन नहीं कर सकते दैट यू नो जस्ट बिकॉज द स्टेक होल्डर्स हैड relationship with a certain outlet, so it gives rise to our concerns of national security. And secondly, court ने हाई कोर्ट के डिसीजन को रेफर करते हुए ये कहा था कि हाई कोर्ट ने अपनी जजमेंट में ये ऑब्जर्व किया ऑन द वन हैंड कि जो उनको हाई कोर्ट के सामने असेंशली जो गवर्नमेंट है उनकी कंसर्न मिनिस्ट्री है उन्होंने जो रेलेवेंट मटेरियल था उनको हाई कोर्ट को सील्ड कवर में दिया ये कहकर कि इस पर्टिकुलर जो ये इन्फॉर्मेशन है दिस इज वेरी सेंसिटिव एंड वी कैन नॉट पुट फॉर दिस इन्फॉर्मेशन टू द पब्लिक एट लार्ज और टू द पार्टीज आउट इन द ओपन कोर्ट देयरफॉर वी आर सबमिटिंग इट इन अ सील्ड कवर. तो सुप्रीम कोर्ट का ये कहना है कि जब हाई कोर्ट ने ये नोट किया ऑब्जर्व किया अपनी जजमेंट में कि ये जो फाइल हमें सबमिट करी गई थी गवर्नमेंट के द्वारा इस फाइल में क्लियरली रीजन नहीं डिसर्नेबल हो पा रहे हैं मतलब वी कैन नॉट मेक आउट सर्टेन कॉन्क्रीट रीजंस कि जिनके कारण सिक्योरिटी का जिसके कारण लाइसेंस जो है वो रिन्यू नहीं हो पाया. ये ऑब्जर्व करते हुए भी हाई कोर्ट ने जो सील कवर का प्रोसीजर अपनाया और उसके बाद भी इस बैन को अपहोल्ड कर दिया. तो इस पे सुप्रीम कोर्ट ने कहीं ना कहीं अपनी थोड़ी सी सरप्राइज और एक डिसअपॉइंटमेंट को जाहिर किया. And now let's understand कि ये significant क्यों हो जाती है judgment. See, a significant aspect of the judgment is that it seeks to end the casual resort to sealed cover procedure by courts by suggesting an alternative approach to state claims of immunity from publication in public interest. So ये इसलिए significant हो जाता है पहला तो because Supreme Court ने जो casual resort ले रखा है कोर्ट ने to adopt the seal cover procedure जहाँ नेशनल सिक्योरिटी की टर्म आ जाती है. सो कोर्ट में ये एक देखा गया कि ट्रेंड है कि कोर्ट्स यूजुअली succumb to this and then court make a resort to the sealed cover procedure. तो सुप्रीम कोर्ट ने ये कहा है कि इसका जो रिजॉर्ट है वो कैजुअली नहीं होना चाहिए. देयर हैज टू बी सर्टेन सब्सटेंस इन द state's argument that you know this particular matter is contentious so far as national security is concerned. So that being one, now drawing upon both Indian and foreign jurisprudence, the bench has said that it is now an established principle of natural justice that relevant material must be disclosed to the affected parties. जैसे यहाँ पे वन मीडिया उनका लाइसेंस सोल इसी बेसिस पे नहीं किया था that you know national security के कंसर्न से. तो the court is saying that it is the principle of natural justice की relevant material जो पार्टी के राइट को कॉन्स्ट्रेन करने के लिए यूज किया गया है party should have access to that relevant material, and it must be disclosed to the affected party. It ensures that the right to appeal can be effectively exercised. It acknowledges that confidentiality and national security, they could be legitimate aims for the purpose of limiting procedural guarantee. कोर्ट ने ये acknowledge भी किया कि national security and confidentiality वो legitimate aims है, however एक casual approach नहीं होना चाहिए. And the court also added that a blanket immunity from disclosure of all reports, it could not be granted, and that the validity of involvement of such considerations must be assessed by the use of relevant tests. So Supreme Court का ये कहना है कि हम एक blanket सा इम्यूनिटी नहीं दे सकते स्टेट को, जब जब वो कहेंगे कि we want to seek exemption from disclosure. Why? Because there is a national security concern. So the court has said that there cannot be a blanket immunity from disclosure, and there has to be consideration जो कि जिनमें substance हो. So to further this end कि हम कैसे एक कोई टेस्ट पे आए, the court has said that it could be ascertained if there is proof that non-disclosure is in the interest of national security, and whether a reasonable person would come to the same inference from it. So court का ये कहना है कि जब भी claim बनेगा कि हम disclosure नहीं दे पाएंगे, why? Because national security is involved. So we have to adopt a test and we have to see कि क्या इस information को देख के एक reasonable prudent person, would he or she also think the same कि there is the disclosure is not in the interest of public. Agar yes, so then we can adopt the seal cover procedure. And also, in order to strike a balance between these two conflicting interests, or balance the public interest in non-disclosure with the one in ensuring a fair hearing, the court has mooted alternatives such as we can take back sensitive portions and give just a gist of the material given to the affected party. And second, जो court ने moot किया है solution इन दोनों conflicting interest को harmonize करने के लिए, वो ये है कि the court can also appoint an amicus curiae who could be given access to the material whenever the state claims immunity from disclosure. So with this, we've come to the end of today's TNA. यहाँ पे I have a question. So in this particular judgment, the court has made use of this particular analogy, and the court has said that it is a principle of natural justice that the party which is affected, it should have access to the relevant materials which are cited against the party by the establishment in order, and which has given rise to the violation of the right of the party. अगर आप ये relevant material नहीं दिखाते हो, तो then जो right to appeal है वो भी further जो है it is affected. And this particular this course of action, अगर जब ये ऐसा होता है, तो इससे क्या होता है कि जो constitutional remedies है जो एक person के पास available होता है to approach a constitutional court, which is termed as the heart and soul of the Indian Constitution, वो भी फिर affect होती है. So my question to you is, which article of the Indian Constitution is termed as the heart and soul of the Indian Constitution, and by whom? Please put down your answers in the comment section. Now, as far as the free study material that LawSikho provides, it is available in the Telegram channel that we have, and our Telegram channel can be made available to you if you click on the link which is provided in the description of this particular video, या फिर आप इस barcode को भी scan कर सकते हैं. Also, अगर आपको LawSikho के contact में आना है with respect to any information, these are the point of contacts for you to get access to our services and to get in touch with us. And the TNA for yesterday, the quiz for yesterday TNA is also made available in the description of this video. You may go ahead and attempt the same, and I would encourage all of you to do so. Thank you for being with us.